Hello, welcome to the second tutorial key points video, and I'm going to summarise what we did in the tutorial. The first thing that we did was to talk about sources of law and how it's made, and I stress that when you're doing research, do make sure that for your own purposes you keep a record of citations, of when you've done a search, the search record. As I say, it's not for me, it's that you've got a record that you can go back on your TMAs, you can go back on your notes and find a source without having to start from scratch again. We looked in this tutorial at the two raw materials of English law. The first is legislation. And what I did was to invite people to discuss within groups, firstly, what are the problems in discerning Parliament's will? And secondly, one group that was answering two questions: do judges make law? Secondly, should judges make law? These are important topics. They're at the beginning of the course, and it's worth spending some time reflecting on them. One thing that really is worth reflecting on is the problems that there are in discerning Parliament's will. What are the problems with language that cause difficulties for interpretation later on? Is it just a question of sloppy draftsmanship, or are there fundamental problems in language itself which create these problems? Because this is so central to English law, do spend some time reflecting on that, and you've got some helpful material in the manual. We stressed the rules of construction, like the literal rule, the golden rule, the mischief rule, and the purposive approach. Again, do reflect on whether they are rules in the sense that we normally understand the word rules. Then there are the rules of language. Don't be overawed by the Latin. It's the principles, which are in English, that are key. Look at the aids to interpretation that are available, the intrinsic aids, those within the Act itself, and the extrinsic aids, things like dictionaries, which can be helpful. And then consider some of the presumptions. These are key to statutory interpretation. Then we looked at the doctrine of judicial precedent, how it works in practice, the importance of that hierarchy of courts, and the rules that apply to each of the courts in the hierarchy. So make sure that you're fully familiar with what the hierarchy is and what the specific rules are for each court. Look at the circumstances that can cause a previous decision not to be followed. And obviously you need to consider the position for the Supreme Court and the position for the lower courts on that. As with legislation, law reports are the law materials for lawyers. So do spend some time looking at legislation, looking at law reports and reading them. Law reports sometimes are not easy to read. Some are easier than others. Lord Denning is a very useful judge to read his judgments because they are very readable. Other judges, I'm afraid, that's less true of. But the more you read full cases, the more that you look at the reasoning that the judge is bringing, the better a lawyer you'll be. We finished off by looking at the English legal system, and again I stress the structure of the courts and the personnel of courts, the judges and which courts they would sit in, the lawyers themselves, barristers and solicitors, the Lord Chancellor and the law officers, the Attorney General and the Solicitor General. Then non-legal personnel, and this is quite important because it often comes up in TMAs and the exam, the role of lay people in the legal system, magistrates and juries. And make sure that you are familiar with the basic outline that is set out in your manuals of criminal procedure and civil procedure. The session finished by my reiterating the comments I made on the last tutorial key points video about TMA 01, and I would stress again the decoding of the question. So question 1, explain. That will get you, that's important, don't just describe. And then evaluate the extent to which you think the view expressed by your friend is correct. I'm not concerned as to what your answer is. I'm going to be giving you the marks for the evaluation that you do. Question 2, problem question, you're asked to give advice. And again, don't write it as if you were writing some kind of legalese. Write it so that your friend Tessa, intelligent but not legally qualified, so that she can understand the points that you're making about the civil and the criminal liability and causes. I also suggested things to look out for as you prepare for TMA 02, which of course isn't due until the 9th of April. It is a long time away, but do be thinking about those issues. You'll see in question 1, you're asked to explain the doctrine of precedent, discussing the extent to which you agree with the views expressed in the above quotation. Same comments as before. I'm not concerned as to what your views are. I'm concerned at the way that you weigh up the arguments that are behind it. So explaining needs to be more than description. What are the key elements behind the doctrine, how it works, and what is necessary to make it work? Discuss the extent to which you agree. That's critical evaluation, weighing up the value of all assertions made and the thinking behind them. Give evidence from judicial lawmaking in practice, so general assertions of principle and precedent. Does it give stability, or could that lead to inflexibility? These are the things to discuss. And cases, cases, cases. I want you to be using examples from your reading to back up your arguments. Question 2 is about explaining the role of juries. So you need to outline the rules, and you need to both explain and weigh up the advantages and claim disadvantages. Now, as I say, there will be some people who will just describe the arguments. I want you to evaluate them, because that's what's going to get the highest marks. Well, thank you for listening, and I look forward to tutorial key points video 3, or seeing you at the next tutorial.